This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
Okay, we might get started. Okay, so we're getting to the busy, hard-working bit of the semester. Plenty to do for all of us. It occurs to this side of the lectern as well. A few things to note. Next week we have Andrew Walker, a barrister, coming in to talk to us about a few things, which will be great. And I had to talk to Andrew about some of the matters we're covering today, so that will be quite interesting. If things come up that you want to hear a barrister's opinion on, perhaps you could save them for Andrew as well. So today we're going to move a little bit more towards the legal side of stat planning and planning law, and you can see the slow progression through the semester. And we're going to have a look at some key principles around the distinction between use and development, characterising a land use and a purpose, and existing uses and ancillary uses. So there's quite a few different things going on there, and as you'll see, I hope that a more sophisticated view and indeed use of the planning system requires that you have a fairly clear understanding of the fundamentals to these processes. So Section 6, and I think as in previous sessions, I will flip back and forth a little bit to the Act itself. So I probably could have started that earlier, but better late than never. Oh dear, what's happened? Oh, I'm in the land of Windows. That was a mistake, wasn't it? Oh my God. You're observing an Apple user trying to remember how to use a PC. How do I... Oh, okay, you do that. Okay. The most fundamental things are going to be slightly challenging. It'll be okay. Lost lead. So, and I'll open another one, which will be planning. Okay, so let's just open up Victorian planning provisions and let's go to the classic. The reason I'm using what they're calling the classic interface is just that I know how to drive that a little bit better, but there's not a huge amount of difference. Okay. Victorian Current Acts, P for Planning, and Planning and Environment Act. Okay, so I need two at once. Okay, so just as a little bit of a recap, Section 6 tells us what can and can't be in the planning scheme. And one of the fundamentals of 6B is worth just relating back to the Act and thinking on what the implications of that are, 6A and 6B. So there we are. And I sort of labour this slightly to make a point that the planning system at its fundamental basis deals with use and development of land in a very particular way that you really must understand to be able to do statutory planning in Victoria. So a planning scheme provides for an area, must further the objectives of planning, and these elements here may make any provision for use, development, conservation, policies and objectives, regulate development, land for public purposes, and so forth. So right down here is one of the key distinctions: regulate or prohibit the use or development of land. So that's probably the most powerful component of the planning scheme, and that's exactly where all of the strategies, all of the policies actually have impact on what actually happens at all the different layers of the urban planning system. So to drive the point home, this fundamental distinction between use and development, sometimes in effect we deal with them at the same time, other times we split those out. In a sense, it's to make it easier and more precise to avoid or include certain things that are going on a piece of land. So you might say, okay, we're not worried about existing structures, but we are worried about what occurs within them, what the use is, or what the activity or purpose is, and vice versa. So if you go and practice in other states, or indeed in other countries, they don't always have this distinction, so you need to be aware of that. So the word development, and hopefully you know this at least a little bit by now, has a particular meaning. It includes construction or exterior alteration or exterior decoration of a building. Do you think that might include painting? I'm getting some nods. You are correct. It certainly does mean painting sometimes, but usually only when there's an overlay that would specify that level of detail. What overlay do you think might be particularly concerned with the painting of a structure? Heritage. Okay, so that's the classic. It could be even that mowing the lawn, if you wanted to push a point, could include it. However, that's seen as general maintenance. But certainly, if we start thinking about what works might mean, if you think about earthworks, so the digging of drains or changing the shape of the land or bringing in material or taking material away or pushing out the site, that's another one that people often don't quite understand at first. But obviously a planning system, it may well be that there is a desire to manage works occurring on land for all kinds of implications, environmental, impacts on adjacent land and so forth. Development also includes carrying out works, or the demolition and removal of a building or works associated with that. Subdivision or consolidation, that includes the building on the land or airspace. What does it mean by airspace when we include subdivision here? And I'm just trying to reinforce or enlarge upon some comments I've made previously. What would airspace have meaning for in terms of subdivision?
Dwellings that are on top of other dwellings.
Absolutely. So we're thinking about the Strata Titles Act, and that now we can buy, sell, own land in 3D. So before the Strata Titles Act, I'm about to have an attempt at using chalk. Here we are. They're all dirty. Wow, they must have been strong in the olden days. Or is it just not getting weak? So, you also have the cough too. So previously it was, you'd own the land in 2D, but now we've got it in 3D as well. So, and so forth. So you can own, I got sick of that fairly quickly tonight. So when you buy an apartment, you don't buy the whole building, you don't buy everything below you or indeed above you. You buy a very specifically and carefully 3D map, effectively, in the air. That has significantly assisted in the process of buying and selling and having property rights in the three-dimensional sort of sense. We were relatively slow to do that in Australia compared to some other places because we just kept building more structures going outwards. So I guess we're still doing that in many ways. But we still call that subdivision. And you do need a planning permit to subdivide, and the Planning Act sets out processes to do that. Some types of subdivision have particular requirements that must be met. Others are more routine. The placing or relocation of a building or works on the land, in some cases, and the construction or putting up for display signs or hoardings. If there is a particular and specific description of development, because even though there will be a physical structure associated with, say, an advertising sign, it has always been slightly vexing to say, well, is it a land use advertising or is it a development? Generally speaking, we consider it a development because it's got a physical structure, but you will also see in the planning scheme there are some specific provisions for advertising. And if you look at the ends of the zones, it tells you which category of advertising that zone falls into, and whether or not you're allowed to have big billboards or small business identification signs, etc. So there's a number of categories, and the essence of that is to acknowledge that advertising signs are often not the most aesthetically pleasing thing in some areas, but in fact sometimes there's a place for them. So most business people want to identify where they are, but we don't want to let them have free rein. So I'll take you to those directly on a different evening. I mention that because often people have never really thought about the fact the planning system might care. So in some areas we let people go for it. Sometimes we have large, what we call super signs along the sides of freeways. But generally speaking, since the 60s, most planning departments or local councils have tried to pull back the amount of advertising because it becomes pretty ugly sometimes. Other times, like the Central City, they encourage good quality advertising. So you can apply for anything, you might not get it unless it's seen to add flavour to the Central City area. So that is worth remembering, that it has a particular set of provisions in the planning scheme. A few things about the nature of development. In a sense, the definition of development is meant to be inclusive, as in if you're not sure whether it needs a permit or it doesn't, or if something's included in development, generally speaking, we conclude that it does need a permit in some way. And there's a class of things, as we put out, with the primary definition in the Act, as I just mentioned. So use is in some ways a slightly more complicated thing, because this takes us to one of the more challenging components of where the planning scheme meets how people use cities and places and buildings and sites. Insofar as, while we can regulate what occurs on land, at some point we can't control every single detail. It usually goes wrong when we try and get too complicated on that. Markets will change, people's businesses will change, people might want to do things that modify the way they use their land, and do we always make them get a permit? So, so I'll take you to that in some detail today, because it does end up being a matter for concern for statutory planners quite regularly. Use itself includes use or proposed use when we are seeking a permit for something, and this word here, which we'll talk about a lot today, for the purpose for which the land has been or is being or may be developed. So sometimes we might say on a permit application, use and development, you're seeking a permit for use and development for the purposes of a warehouse. So there are two things going on. One, a permit's being sought for the use of the land as a warehouse, and that has a range of characteristics that need to be met in the planning scheme. And for development for a warehouse, which is the structure being put up and the loading bays and where the goods are stored and how trucks move around from the site at different times of day, etc. And that there'll be roads provided for them. So sometimes we mix them together, other times we split them out. Again, it's the intention that that definition is relatively inclusive, and in the Act, of course, we have tried to define them fairly carefully. So, what are the main things we need to think about when we consider use and development? And just to stay with this sort of this principle of being fairly careful about these things, if we go down to clause 32 or 32 will do, or 3203 maybe. Oh, go away. And we start looking at a particular zone. Of course, you know this a little bit, but let's dig into it a bit more deeply. We have the table of uses. We're breaking that into 3. No permit required. But one key point to remember here is that we will have a land use over here, but sometimes there are conditions. Okay, so they may or may not be there, but they provide us a greater level of detail associated with the land. Now, let me ask you guys a question. If I wanted to know what animal keeping is, other than animal boarding, where would I go to find that out? Definitions, clause 74 of the planning scheme. Okay, so that's a good one to know kind of off by heart. There's another class of definitions under clause 72, which is general terms. So if you wonder, oh, what does that mean exactly? Normally you'd go there first, or you would look for the definitions that are set out in the Act. There aren't too many, but they're, perhaps the more important ones to start with. So, what happens if what you're proposing doesn't meet this condition? Say you want to keep animals, it might be goats, and remembering that you're in the low density residential zone, where things might be a little bit more open to doing things like keeping animals. What happens if you don't meet this condition? You need a permit, and why is that? So if we go back, well, there's 2 ways, I think. I think we still have this written in here. We've written it in there. Oh God, that's long. No, I'll take you back to the proper source, but if we go back to, it's very slow. Okay, so if we look at the operation of zones, so what you've got to do is really get the habit of knowing exactly where something is written down that is the rules. So get the habit of going looking for them and knowing them. So here it tells us what a Section 1 use is, and here it says any condition opposite the use must be met. So that means if I'm keeping animals in accordance with that definition in clause 74, could be goats, sheep, I don't know, and I am meeting that condition, no more than 2 goats, that means I don't need a permit for that land use. If the condition is not met, the use is Section 2 and requires a permit, unless it's actually in Section 3. Section 3 means it's prohibited. Okay, so that applies through all of the different zones, that concept. And it's a pretty powerful imposition on what does and doesn't happen on land, for whatever the definition is. Okay, so this fundamental test of development versus use it's part of this fundamental control of what needs a permit and when, what might be considered in terms of the decision criteria, whether or not you've applied for use or development, and in fact whether you have rights of appeal. Okay. So, each of the zones has a schedule, and it tells us what Section 1, 2 and 3 are under Clause 31. And of course, if we look at subdivision, here it says under 3208, but it will apply to each of the zones, of course. A permit is required to subdivide land. But what does this mean here? Clause 3208-11. An application to subdivide land into lots, and this is for the particular zone, is exempt from 52(1)(a), etc. What's that about? Saying section, that's a bit of a clue to start with. I thought you guys would be guns by now on this. It's not a clause, it's a section. So it's the Act. And what's Section 52? It's sort of that. If we look at, you're getting close. So if you look at Section 52, this is like one of the big jobs we're doing all the time in stat planning. I'll get you to read it. To give notice. So with subdivision, most of the time it's exempt from giving notice. Most of the time. It depends on the zone. So what you'll find has happened over time is there are more and more things that the planning scheme has made exempt from giving notice. And what that means is there aren't rights of appeal in many of those cases, or it's not rights of objection and subsequently appeal. So while I have said to you that we have quite open rights of objection and appeal, actually they're being trimmed back slowly over time, mainly because we're trying to find ways for everything to go faster. All this streamlining and smart planning, etc. So it's worth reading that clause carefully, but you'll see that these are kind of curtailing many of those rights. Part of it is based on the fact that there will be other provisions of the planning scheme which will still allow careful consideration of use and development, say with medium density housing. And subdivision, it would seem superfluous to have already made an assessment about the development and the land use, and then to have to open it up again for subdivision would seem to be a redundant process. Does that make sense? So often it's not quite as bad as it might look that there are no appeal rights or objection rights, for section for subdivision because it's already been picked up under use or development permit requirements. Okay. And this classic sort of phrase, section 2, permits required to construct a building or carry out works for a use in section 2. So often what will happen is that this clause will tie the use and the development, the building and works, together. So as soon as you need a permit for section 2, you also need a permit for the buildings and works. It's quite a common mechanism to join together use and development, both needing a permit at the same time. So if you look down the zone provisions, you will often see this. So a good habit to have if you're investigating a site and say your client or a member of the public or whoever is trying to work out what the permit triggers are, it's a very good idea to just slowly work your way down through each bit of the zone and indeed overlays. To consider that very, very carefully, because you might, if you miss that, you're missing a fundamental component, as in that buildings and works need a permit. And you won't, well, it'll be prohibited for a start. And then, characterisation of use. So if we go now to section, well, I guess it's applied in two ways. When you're applying for a permit into the future, you need to characterise what the use is, but perhaps there's an issue already with something that is already an activity occurring on land, or perhaps the activity is changing slowly over time. So if we go now to clause 74, zip down, we'll have a little detour to clause 72 so you know what that is. What? Okay, these are general terms. Actually, why don't we do this too? Meaning of words. So this is an attempt to try not to define every single word in the planning scheme, although there are a heck of a lot of words in there. A term used in the scheme has its ordinary meaning unless the planning scheme or the Act give it a special urban planning definition. And if you want to define a word and it's not in the scheme or the Act, we use the Webster Dictionary, which is the Australian dictionary. The Macquarie, I mean. Is it the Macquarie? No one ever uses that dictionary, I might add. I certainly don't have a copy. Maybe there's an online one. But I guess that's where you might find out what a proper Australian spelling is, because we're mixed up between US and UK, aren't we? So generally speaking, we will try to go to that Australian definition as a way of stopping the planning scheme just getting bigger and bigger and bigger. But if you have a look at, how does that bloody work? I see. There we go. We go back to there. Okay. So if we go to 72, these are general words that aren't uses, but they're general terms that are used in the planning scheme. And even though these might seem somewhat slavish and obvious, they're actually really important if you're in the middle of a decision or trying to rein in a developer's or even a resident's expectations. There is an actual meaning of the word in the planning scheme you can fall back on. For example, this comes up again and again, basement. It's not my water. A basement, a storey below ground level or that projects no more than 1.2 metres above ground level. Why do you think they might have gone to the trouble to define that general term and put an actual number value on it? Why would that be so important? I mean, the planning scheme has reference to how many stories things are again and again, doesn't it? You know, 3 stories or 4 stories, or when does it become an apartment, and those sorts of things. So if I was a developer trying to push the envelope, I'd have a basement that projected 2 metres above ground, or 2.5, and say, oh, that's not a story, that's a basement. But I could, if I'm the town planner, I'd say, well, no, it's not. It's more than 1.2 metres above ground level. So these things need to be carefully set out so you have some precision and some certainty that people aren't going to misuse the system. I make it sound like everyone's misusing the system. That's not true. But you do need to expect the worst, unfortunately, in some instances, because not everyone will necessarily go along with what you see. Okay, so the real direction I was trying to head here, of course, was to look at land use terms, and these will be a key component of some of the case law we're going to look at today. And in here, you'll see these are just sort of preliminary comments. And if you go down, they're in alphabetical order, and you will immediately see that is a nested set of concepts. And I'll show you the diagrams that interact with this or that replicate this. Accommodation might be called an umbrella term in some ways, because it includes a whole range of other things that are underneath that broad definition of accommodation, and they're more specific. And if you went, say, to camping and caravan park, you would find that it is more, it's not a huge amount of detail, but it provides more detail about exactly what is included within caravan and camping and caravan park. Land used to allow accommodation in caravans, cabins, tents, or the like. But you see this column over here, it tells us what it is included in. So that's the top part of the hierarchy. So if my client wanted to do something, I would probably be very careful to look at the aspects of the zone, and they'd say, oh, I want to build a house. I want to build a house. They say, well, do I need a permit or not? So, well, a house is the structure, actually. We tend to think that means a dwelling in general terms. So what do you want to do in the house? What's it for? To live in? Or do you want to run a bed and breakfast? Or is it a dwelling? You want to run a home business there. You're going to live there and conduct a home business. So these definitions are actually really important, particularly if you get a permit for something, or your client gets a permit, and it's not actually what they want to do. So if you were to go out and get a permit for a dwelling, and then you wanted to actually use it for food and drink premises as well, as in you wanted to run a restaurant out of it, well, you'd be breaking the law. So yeah, but it's got a kitchen. Why can't I run a food and drink premise? So this getting the definition just right is important, and this is a classic. Place of assembly, or a place of assembly. It could be a church or a mosque or a synagogue or a temple, etc. But are you allowed to conduct those things in a house? Are you allowed to have people assembling in your house when you have a party? So this grey area is kind of impossible to get rid of. You can get more precise, but you can't get rid of it completely. And I'm not trying to sort of deliberately confound you. Where's place of worship gone in here? Oh yeah. So we don't have place of worship, which is synagogue, church, mosque, etc. So what do you think would happen if I wanted to have a place of worship in this zone? And it's not shown in here. Do you recall, where are we? It's what we call an inanimate land use. And basically it means if there are very few of them nowadays because we've defined the heck out of everything. But generally speaking, if it's not included in section 1, 2 or 3, it's an inanimate land use and it just requires a permit. Nowadays often it says if it's not included in section 1 or section 2, it's prohibited. So you have to read through very, very carefully what you're looking at. So the characterisation of land uses is one of the key drivers of what needs a permit, what doesn't, what's prohibited, but also it can often be part of enforcement action to decide whether or not someone's doing something illegally or wrongly or in a prohibited way, or if they can just keep going. So there's just a reference to clause 74. However, it's not just as simple, if indeed that is simple, of working out whether or not it lands in one of those definitions. Well, it can be that simple, but sometimes it's a bit more complicated. And the reason for that is that often we are actually mostly interested in the purpose for which the land is used. This is most commonly a problem in existing use rights and when we're looking at ancillary rights. These are more common questions than you probably would imagine because the city is a dynamic place with people doing things and conditions change, but the buildings don't and the permits don't, and some places never even got a permit because they've been there for 100 years. So as soon as you start packing more people in and people start complaining and the zone doesn't protect me, etc., you have to end up working out what has existing use rights and what is an ancillary use on the land. So one of the key processes is this two-step process. What's the actual purpose? And then see where it lands in the table of uses and the definitions. And I will kind of reveal a little bit more what I mean when we have a look, and I'll see if I can get this to work rather than look at it electronically. I think in some ways it could be easier to look at it in the document camera. Okay, so zooming. I know this is a little bit of a pain. Can you guys at the back read this? That's a no. Okay. Maybe I was over ambitious with that. Okay. How's that? Nods? Yeah, I'm getting nods at the very back. Okay, that's a good sign. Righto. So, here is where case law actually really has had a huge impact and continues to have, well, one example, where case law has a huge impact on statutory planning. And we'll follow we've got a few weeks where we'll be looking at this as one of our focuses. This is a famous case called Shire of Perth versus O'Keefe, and it goes through some of the key steps. And this has changed slightly over time and become more specific as further cases have existed, but this one still drives a lot of our understandings of existing uses. So what I will do now is take us to clause 63. Has anyone had a go at clause 63 of the planning scheme? Because this one is a bit of a driver and will provide context to the whole thing. 6301. I'll flip over the screen in a moment. Now, righto, extent of existing use rights. An existing use right is established in relation to the use of land under this scheme if any of the following apply. So what does that first sentence mean? What is it meaning if you have an existing use right? Predates it, and it means that you can still keep going, even if you don't comply with the planning scheme. So you can be in the general residential zone and you can be carrying out industry, and off you go, you keep going, even though it is Section 3 or prohibited in the planning scheme. If the following apply. So, the use was lawfully carried out immediately before the approval date. Here, approval date refers to the approval date of the planning scheme and or the detail to which it applies in this instance, like changes to zones, overlays, etc. The permit for the use had been granted immediately before the approval date and the use commences before the permit expires. As in, they got a permit, they started it, and it becomes an existing use. So you can't immediately turn around and say, oh, we'll change the planning scheme. You've got to stop your highly profitable business. That wouldn't be fair. So this is one of the principles, even though we do other unfair things in the planning system, this principle holds quite strongly. It's about property rights. A permit for the use has been granted under 6308, which I'll show you in a moment, and the use commences before the permit expires. Or proof of continuous use for 15 years is established under 6311, or the use is a lawful continuation by a utility provider, etc. So this is then suggesting to us that if you're already doing something, the word use, the activity, then keep going. Get rid of that. And we want to look at 6308 and 6311. If land is used for a use in Section 3 of a zone for which an existing use right is established, a permit may be granted to use the land for an alternative use which does not comply with the scheme. So essentially, this is providing a way of modifying the use on the land, and the main test is it going to be better? So it's a way of trying to gradually improve the land use so it has less impact on the area. Developers love this one. It's a bit of a trick not many people know about, because you can say, well, we're not going to have a factory anymore, we're going to have offices even though that's prohibited, but at least it won't have the same impacts on that lovely, that lovely residential area. So that is another way of getting existing use rights. And proof of continuous use. And this, so if you think back to the earlier clause we looked at, existing use rights exist if ... An application, the extent of any existing use right for a period in excess of 15 years in his question, it is sufficient proof of the establishment if the use has been carried out continuously. An existing use right may be established under this clause even if the use did not comply with the scheme immediately prior to or during the 15-year period, unless basically someone complained about it or did something about it. So what's that mean? In your words, what do you think that means? In plain English. So even if it was a bit dodgy and not necessarily in compliance with the planning scheme, if no one complained for 15 years and you kept going continuously, now you've got existing use rights. So, yes?
They
Transfer.
buy.
Yes, they do. It does. It does. As long as because let's talk about use. It's got nothing to do with who owns it. Yeah, that's right. So generally speaking, planning rules, including permits or existing use rights, run with the land. Now that's pretty important. So good question. Because say I had a lovely, I don't know, metal recycling plant and it didn't comply, but it was my family business and my grandfather and my father, and I wanted to give it to my son, so I transferred it over to him because we love metal recycling and transfer stations. Well, to not be able to do that would be a significant financial hit. So you can sort of see where the planning system's sympathies lie, can't you? Business and property in many ways. And I'm not saying that's a bad thing. I worked as a planning consultant for 15 years, so I do lean that way, I suppose. So that's proof of continuous use. So let's go back, and we'll have a break in about 10 minutes, to this. So this is one of the first cases that really set out some detail on what an existing use is and how you work out what it is, because there's some nuance there. It's not just the definition of the use in the zone or the planning scheme. That is too imprecise. So if you look at this one, there's a few things you might want to take note of. This is the High Court of Australia. It's not the Supreme Court, it's the High Court. It's right up there. So this one started off in WA. It went to the Supreme Court. There was still a matter of law to be considered, so it went to the High Court of Australia. So a lot of money was spent back in 1964, 65, to establish these key principles. So in some ways it's not surprising, it's very rare for that to happen. And you'll see here, there's a little summary at the start, and when it says held, that's a brief summary statement of what this court found to be true, its decision that it came to. Held that the land might continue to be lawfully used for pottery making, but not for the purposes of any other activity within the category of light industry. And in many ways, that's the main meaning of this whole case. Just because something lands within a use definition, that is not enough to characterise the land use precisely in terms of existing use rights. We'll talk more. The way you do it is work out the purpose of what is occurring on the land. So that's another key word you'll need to understand. So who's read this case? I had struggles with the LMS. Great, a few people have read it. The LMS fought me, and I realised it doesn't like Safari anymore, and I have to use... I say this because maybe it might happen on your end sometimes. I started using Firefox, and off it went. The penny dropped, after Sunday lunch, and I hadn't even been drinking. So it's worth trying. It's like stopping the computer and starting again, use a different browser. So who wants to describe what just happened? What are the main facts of this case? Excellent. I see who just said that now. It's a bit weird when you can't tell who it is. So say that again. It was already... Okay, and it was a pottery factory thingy? That's right. Yes. Or part of the use of the land had changed to that for a certain time period. That's right. And so you'll see here, and we'll come back to the detail of those comments, so thank you for those. And you'll see here there's a few things, and of course we're going back a little while, 1964, what's that, 54 years ago, 54 or 55 years ago, that, strange, it's an easy sum for me, you can guess why maybe, but so here there's reference to what? What are these down here? Previous cases. So they're building, so these are here for the building of knowledge, so we don't have to go right back to the beginning every time, but building up that knowledge and intellect and precedents set, so we improve the sophistication of our decision making over time. So if you go back to these, and it's a few years since I did so, but you'll see, you know, the nascent building of this understanding about the real and substantial purpose over time. And indeed, to what these principles were applied, because that is sometimes part of this understanding as well. So we won't go through all of the detail, but we will go through some of it. And one of the key things there, oh, that was lucky. I'll just give you a bit of context. The permitted uses of land and buildings classified within a residential and flat zone did not include the use of such land for pottery making or any industrial or light industrial purposes. I'd hasten to add these are talking about bylaws, because that's before Perth had planning schemes called planning schemes in that sense. But this is one of the really compelling and interesting things about planning law, is that it's the principle that drives it. It's kind of like the intellectual level, and of course the detail and context is important. But the real value of these is you come across a new set of circumstances, and indeed maybe some of you already have, and you can still apply these high-level principles to those circumstances. And if you practice in planning at all, you'll definitely come up against this real and substantial purpose test, existing use rights and ancillary rights as well. So the first thing we've established here is that, well, pottery making is not something which you can get a permit for, normally in these places. But as we know, it was an existing use. And I'm trying to just so there's history on this page, but I won't go through all of that in huge detail. But here you can see bylaw 372.1. It was provided that if at the date of these bylaws being gazetted, any building or structure being lawfully used for a purpose or built on in a manner not permitted may continue to be used for that purpose or in that manner, but no such building or structure shall be added to or altered unless special permission to do so is granted. So you'll see there's a constant repetition of that principle throughout all of these cases and tribunal determinations. And essentially it's saying we're not going to stop people continuing to do what they're doing, but we won't let it intensify, and in some places you'll see, and we'll even try to get it to be reduced in its impacts over time. Hence that exemption clause under clause 6308. So we go through and you'll see here, what are they doing here? It's beautifully clear, isn't it? McInerney, etc., looking at a particular case there. Purpose means the actual use to which the land was put. There then must be continuity in the use, and you'll so you see some references there, and I'm just going to flip through. Okay. According to an agreed statement, so the different parties actually agreed that the pottery had still continued, and that was for the purposes of pottery making, and that you could continue to do that under light industry. But the real thing that this case turns upon is this question of, just because pottery falls within the definition in this set of bylaws, what we now call, hang on, I'm getting too excited. What do you think it means? Why are they so bothered by the purpose of pottery in this context of light industrial? I do get carried away. And why? So it turns upon something super important. You are absolutely right. So, so I'll just repeat that. If you were to say, oh, pottery falls within light industry, and therefore you have an existing use right to continue light industry, that could include metalworks and all kinds of noxious, at that time, and problematic land uses that are far worse than pottery, potentially at least. So we're not going for the land use definition, we're going for the purpose. So purpose is a super important word there, and indeed it gets more complicated or more complex over time. So it's going back to these fundamental principles of trying to improve the ability to achieve the local government's goals and to rezone it and to not allow light industry normally is to say, okay, we're trying to minimise those sorts of impacts. So we go down to the purpose rather than the land use definition that it falls into. So it goes so far here as to set out steps. And first, it is required that a purpose be identified as the end for which it can be seen that the premises are being used at the gazettal of the bylaws. Not the definition in the use category, but the purpose. Do that. And then you say, well, it could be continued to be used for that purpose rather than the overall use. And perhaps in some cases, conditions might be attached to that depending on how those existing use rights are arrived at. So there's still plenty of grey areas there, because what if their operation, they started making a bit of money and it got bigger and bigger, you know? So, you know, there would be other concerns there. But generally speaking, that sets out the main. And there's a nice little sort of indication there. If you want to read into this more, there's a few great little examples. You know, looking at a butcher's shop, not of a shop generally. You know, so it's not a hardware shop. It's not, you know, in all the other possible shops. The purpose would be what we normally understand as a butcher's shop. So it's actually a really useful case to set out all of those things. And then we get to this part. So here it comes down to essentially what is the decision being made here. For the reasons stated, I'm of opinion that the declaration made in the order now under appeal, as in the one from the Supreme Court of WA, describes too widely the purpose for which the respondent's land was being used at commencement, and it should be replaced by a declaration that the only purpose for which the bylaw permits is the purpose of pottery making. So one of the other things to consider here is just the reading of these cases and getting the hang of how they set things out. Now obviously this is the High Court way back in 1964, but it's not terribly different now actually. Okay, so any sort of broad questions about that? I know that's a lot of ground to cover, but I think it's worth stepping through these, because all these decisions, wherever they are, High Court, Supreme Court, but usually VCAT, it's a huge resource to deal with complex matters, and you guys should be able to do it by the end of this subject, or begin to do it, maybe with a little bit of assistance now and again. Let's have a break, and let's start at 25 past, and we'll have another run through of a couple of other things. Okay, so we were looking there in a small way, just the beginning in a sense, of existing use rights. There's another quite closely related principle. Many of the approaches used have at least some overlap, which is thinking about land being used for more than one use. So essentially, Well, let's just read what the planning scheme says, because I think the first time I read this, I thought, wow, that's kind of ambiguous and somehow glib. If land is used for more than one use, and one is not ancillary to the other, each use must comply with the scheme. It sounds really obvious, doesn't it? If you've got a, I don't know, animal keeping and animal boarding and, I don't know, motor repairs, each of them need to comply with the planning scheme. But there's a little out in this clause, isn't there? There's a little exemption. What would that be? There's a little bit of relief or similar in terms of the land use there. Ancillary. So it means, perhaps it means, that if something is ancillary, it doesn't have to comply with the planning scheme. It's pretty much what it means, isn't it? So I'll illustrate. But so let's just read this backwards, so to speak. Uses must comply with the planning scheme. Okay. If you've got more than one, one of them that is ancillary, or others that are ancillary, don't need a permit or don't need to comply. Okay, so now when we go back to this word purpose, it adds another flavour to it, because it's the purpose, not necessarily the use definition, that drives things, as well as this idea of ancillary. So let's just consider, maybe, let's have a think. Okay, I'm in the low density residential zone. I've got a dwelling, and I like to look after my friends' dogs when they go overseas. Am I in contravention of the planning scheme? Because I'm providing animal boarding services. Sounds like I'm breaking the law. I'm getting nods and shakes of the head. Doesn't say, does it? How do we know? Well, that's animal keeping, but what about boarding? They're staying with me, they're boarders. So I guess it depends on the purpose, yeah. I think so you could, in a sense, I'm not trying to solve that right now, it would depend on the circumstances. That's the starting point. It's not a one-size-fits-all in these cases. I suppose you would be looking at the purposes. Essentially, what the planning scheme is kind of struggling with is that, yes, we can set up a whole bunch of rules, but imagine going around and trying to work out all the details all the time. Like before, when I was a student, I used to service my own car. Is that being a mechanic in the driveway? So where does it end? How do you deal with those matters? And so that is partly what this clause about ancillary uses, clause 6401, is trying to deal with. That there is a grey area of sorts that is necessary to the operations of any land. Otherwise, it's too rigid and it'd be like living in Switzerland. Anyone lived there for a period of time? It's hard work. It's rules about everything. Wouldn't suit us. Apologies to my Swiss friends, many of whom are close. So the thing that is necessary here to operationalise this is an understanding of ancillary uses. And I'm trying to go here. So, here is a case, and it's sometimes referred to as the Video Easy case, if you've heard of that one, because the people operating the shop and the warehouse were Video Easy people. So you might hear that referred to. Again, this is quite an important case. let's go up to the top there. It was in the Supreme Court of Victoria, which means what happened before that? Before you get to the Supreme Court, something's got to happen. VCAT and someone has appealed a matter of law. Someone said this is not a proper legal approach. You've essentially broken or misinterpreted something in a legal sense. So this was 1993, and there's a number of things that come out of this case, but this one is very, very, well, I guess you could say popular or commonly used even now, although there's more nuanced uses according to circumstance still based on this, because it sets out a series of tests around this phrase of the real and substantial purpose test, and each of those words is important, and it helps us to understand what a use is, and sometimes what an ancillary use is. It's like a sub-test of the ancillary measures that you might apply. You can see here a reference back to Shire of Perth versus O'Keefe. So building on that case law over time, and putting to work some earlier principles that had been developed in the High Court in the Supreme Court of Victoria. And, well, maybe you guys could talk. What did this turn upon? What was the big concern here? And what were the facts? Does anyone want to take us through those or some of those? It takes time reading these, I will admit. I didn't give you much time. So, I saw a half-raised hand. Yep. Yep. Yes, you're bang on. So they've got a permit for warehouse, and a warehouse is a particular thing insofar as the activity on that land. Well, we've got lots of definitions now, haven't we? Where's W gone? I don't know where it is. Let's just get there. What is a warehouse? And, fairly precise meaning here, isn't it? Land. Sorry? You can't see it. Oh, I see. Beg your pardon. I need one of those little beepers like when you leave the lights on in the car or something, don't I? Okay. Warehouse land used to store or display goods may include the storage and distribution of goods for wholesale, as in not individual items but en masse, packed up, and the storage and distribution of goods for online retail, not include premises allowing in-person retail or display of goods for retail, or allowing persons to collect goods that have been purchased online. Now that's a pretty clear meaning. This is like, pallets and big boxes of goods going around the place. It's not people walking in and saying, "Can I have one chocolate bar, please?" So these guys at Video Easy, and I'll let you read it in more detail, but and I'm putting aside some of the micro detail that's not necessarily pertinent, they had quite a big operation there, and they set it up so essentially it looked like a big shop. And their arguments, and I think it was quite a successful business case when videos were an important thing, I guess, back in the 90s. Anyone doesn't know, it's like a cassette tape. If you don't know what a cassette tape is, before discs. What's a disc? Anyway, so they set it up like a shop, as if it was kind of like a video store, a suburban video store. So you'd walk in and you'd see the display signs and you'd see the videos. And, I reckon people would go for that. And here's some promotional material I can get at the same time to make my store look cool and get more units moving and all that kind of stuff. And and the tribunal says, yeah, fair enough. That's a great use of a warehouse, because you get clients coming in and they can get the whole experience and they get information about sales and the statistics of certain things. You know, it's all part of that. That's cool. But then they also decided, well, we're going to let people come in from the general public and we'll watch what they do and we'll learn from how they are engaged in a retail experience and what seems to attract them and what they understand and don't understand. And then they said, oh yeah, and we'll also offer repairs to video machines. It's just quite funny because those things really did break down a lot now I think about it. So we'll offer repairs to video machines and we'll include sales of video players as well. And so you can see, as is often the case in these circumstances of ancillary land use, there's creep. Things start out one way and they slowly change over time. And so the question then comes, okay, do you think that there's more than one use occurring on the land? Sounds like there's sales, sounds like there's retail. You know, so it does sound as if it's more than warehouse. You know, if we go back to this warehouse definition, you know, it certainly does sound like retail, doesn't it? And members of the public coming in. So I think in a broad, in a very direct and specific understanding, it sounds as if they're not complying with the planning scheme, because retail is prohibited in that zone. So, what happened? So if we go down there, the consideration that takes us directly to what did this turn upon? Consider of the application of the principles to circumstances where premises in the light industrial zone for which peripheral sales and warehouse and inanimate uses, unnamed uses, were permitted, where the premises were being used for wholesale distribution, sale hire of video cassettes to retailers. So then it came down to, okay, are the other things that are happening on that land allowed? And I don't want to sort of go through too slavishly, but I think it's worth looking at this. The history is sort of complicated. Well, does anyone want to, again, I'm taking over. What generally happened? What were the steps that we went through to get to the Supreme Court? Sounds like I didn't give you enough time. I forgive you all. Essentially, someone didn't like it. They said, okay, well, can we say that it's innominate? And it went to the tribunal, and I'm summarising like crazy. These sort of things are descriptions of what they were doing. I find that strangely entertaining. And then there was a decision by the responsible authority. So the council cited two grounds for refusing a permit: the sale or hire of video cassettes from the video display area constitutes a shop which is prohibited in the light industrial zone. So they went back to seek a permit so they could legitimise their operations. And they had tried to have it formalised by having it considered as an inanimate land use, as in it wasn't described in the planning scheme already. This sort of process of displaying and gathering data from having retail within your warehouse. And they were also concerned about precedent, but this is largely about, okay, just because you can define something according to one of the land uses in the planning scheme, does that mean that's what it is in terms of ancillary versus as primary land use? So just because you can fit something into a definition, does that mean it's how we understand whether or not it's ancillary? So just because I look after my friend's dogs, does that mean I run a boarding house for animals? That's where I'm headed. No, it doesn't. But this principle of an ancillary land use and the tests that you apply to it, because it's so specific and particular to a place, is how we work that out. So they had a go at inanimate land use. That didn't work out. And this is sort of relevant. You know, things that they could have is peripheral sales. This is an old definition. I think it's kind of different now. That meant like lawn mowers and farm equipment and stuff like that, or warehouse. So clearly retail sales did not fit into that. And here, this in the old format planning schemes used to be clause 12, now it's 64.01. And the tribunal started working its way through this process of deciding whether or not it was ancillary, what was occurring. So the tribunal, this is what we now call VCAT, back then it was called AAT, as Administrative Appeals Tribunal. The uses were to be characterised as warehouse, peripheral sales and shop. Use of a shop was prohibited and not legitimised as use ancillary to use of a warehouse. So what the tribunal did here, it made an error of law. It didn't apply the real and the substantial purpose test. So that's why it went to the Supreme Court. It's easy to be slightly smug after the event, isn't it? But so they got it wrong. But you know, this is kind of establishing the processes back at this time. But I do take a slight thrill when tribunals do something wrong. So its reasoning plainly showed that the permit granted did not legitimise the second appellant's retail operation. Anyway, getting complicated. And then this is where it gets a bit rough on the tribunal. Mr. Hooper made a wide-ranging attack on the tribunal's reasons, which he contended were infected by misdirection at various points and unsustainable findings of fact. At the core of his submission was the contention that the tribunal erred in not determining the use by the application of a real and a substantial purpose test. He submitted, had such a test been applied, that its purpose would have been revealed. That use would have been one reflecting the accumulation of activities undertaken at the premises. It would not have been a use fitting any of the defined uses in the planning scheme, what we would now have under clause 74. It should have been regarded as falling within the inanimate use. So even this became contested. So, I won't subject you to me reading it all out, but Mr. Hooper conceded that application of the real and substantial purpose test might in a particular case lead to the conclusion that two or more distinct uses have been disclosed. Therefore, they both need a permit, and that, we'll leave that alone. But it is convenient to now deal with the matter on the footing of the finding made that there were three distinct uses of the premises. So this is part of the steps you need to go through. What's happening on the premises? Warehouse, peripheral sales and shop. But is that really the purpose? Okay. So here we get down to what it goes on and on. I'm just trying to find the key bits for you to see. And I think it would be a very good idea if I was studying for the exam to have read this with great care, because an examiner might want to see you use this in a different circumstance. Wink, wink. Yep. Hang on. Tony Abbott made that unpopular. I would take those 2 weeks back. If you're not up with Australian politics, your Australian friends can explain. No winking. So here's where the judge starts setting out how to attack this problem. It is, in my opinion, clear that the board, and it was called a board back then, misrepresented itself in its approach to determining whether the shop use was ancillary. And we go through, yeah, and basically he's saying why the tribunal went wrong. So I won't sort of twist it around too much. Now, here's an important point. It follows, the matter must be remitted for rehearing. This is an important point for the Supreme Court. It doesn't make a decision as to whether or not something's prohibited or whether a permit issues or what conditions. Rather, it sends it back with an affirmation of what the principle of law should now be understood as, and then the tribunal has to apply that properly. So it goes back to the tribunal, so now you guys make a proper decision with your principle of law sorted out. So that is remitted for hearing. And I've made... Now, so this is probably a bit complicated to read it all out, but here we're getting down to brass tacks. The judgment relevantly addressed purpose. Defined term described not an activity or use, but a purpose. So that's what you're going for. And there's a lot of precedent and case law set out as well. So here's a good reference on page 379 to existing uses. So it has a little bit more detail on that. Over and above O'Keefe versus Shire of Perth. And essentially it's saying we can use this real and substantial purpose test both with existing uses and with something for which a permit is being sought in the future. So it's got more of a range than just ascertaining existing use rights. We are also meant to use the real and substantial purpose test for things that are being proposed. So a lot of principles are set out in this case. All right. There's a case here where this principle is applied. It's a good little example actually, because this is talking about advertising signs and whether or not they are considered ancillary in this planning scheme. So that's a good one to go to on page 381. And here, where you can't see, it's talking about how you go through these tests. And I'm going to take you to those on the first page. But before we go back to those, just to reiterate, what happens? The appeal be allowed, meaning the appeal was that there was an error of law being applied. So the Supreme Court is saying, yes, there was a problem. We set aside that previous AAT decision. And it goes back, it's remitted back to the AAT for rehearing. Okay, so let's just drill down to the core message we're getting out of this. Okay, the following principle apply when we're trying to work out use, but more specifically, the purpose, to understand whether things are ancillary or not. The purpose of the land must be ascertained, which is a narrower thing than the use. You can certainly apply for a use. This is not saying you can't apply for a land use. I'll talk about that in a minute. Because this is for ancillary. We're trying to define ancillary, where you do use the purpose. Okay? It is wrong to determine the relevant purpose simply by identifying activities, processes or transactions and then fitting them to some one or more uses as defined in the scheme. You're looking for the purpose, when, particularly in an ancillary land use setting. They're really reiterating a few things there. Where more than one separate and distinct purpose is revealed, the question whether one is dominant is to be asked, followed by the question whether the lesser purposes are ancillary to the dominant purpose. So I didn't take you to these, but part of this case was it was set out that this warehouse was massive. It was supplying all of the Video Easy stores in Victoria, so a huge operation, and so the retail premises were considered really quite minor, and indeed they were. So a very small part of the operation, so we could say it is ancillary to the dominant. Ancillary, you know, a small part kind of next to but related this major warehousing operation. This case established that yes, warehouse is dominant and that the retail is ancillary, and that we should be applying this test set out in O'Keefe and Shire of Perth. So, that might take a bit of time to absorb. I'd recommend reading it. This comes up again and again in the planning system. A lot of times people sort of skate over the surface of it, but you guys doing this subject should be able to dig into that and in fact apply it to other circumstances. Okay? So, but I made a comment. If I was going to apply, let's look at this. So imagine I'm a planning consultant, which I guess I kind of am. What I'm going to do, okay, there's a good way of doing it. Let's go, so there's a very cool thing here, if you find this stuff cool. The nesting diagrams. Oh, they're not there, the next one down. 75. Okay, so what these do quite conveniently is tell you what the big umbrella term is and what falls underneath that, and indeed some that fall even further down. So if I was going to have a client who said, I want to get a permit for a backpacker's lodge in this existing structure, I say, oh, that's okay, yeah. But what I would say to him or her is, why don't you get a permit for accommodation, actually, if you can? Why would I say that? If I'm trying to think of his interests. Heaps more options. Heaps and heaps and heaps more options. Now, council might not like it, but often they don't have a problem with it. Why would you restrict a business person's options? Unless there's a reason for it. Maybe you don't want a host farm going on there potentially. But generally speaking, you know, if you had the chance, you would keep the opportunities on a piece of land more open if you were thinking of the interests of that landowner, wouldn't you? Yeah? So this is talking about the land use, and if you seek a permit, it is usually a good idea to, you're seeking an actual land use under the terms of the planning scheme. Now, it is possible that the responsible authority might be very, very interested in the purpose to which you're putting the land, and sometimes they do try to drill down very specifically because they want to think about the impacts, perhaps, of a certain land use. But if no one's too worried about it, when you make a planning permit application, generally speaking, you might want to sort of move up the hierarchy of land use terms to maintain options a little bit. I mean, I suppose that might mean if he had a desire, he could run a corrective institution. But I'm not trying to make light of it. But so generally you go up. to a higher or more open definition of a land use when you try and get a permit, if you feel that there's a need to anyway. Sometimes you can't. Sometimes those use classes in the zone have very specific things in there, don't they? They might say dwelling doesn't need a permit, but group accommodation does, so you've got to still fit in with the provisions of the zone. But there's a bit of craft, stat planning craft, in getting the right land use definition in what you actually apply for that can really make a difference. But when we're interested in the purpose, it's because we're trying to characterise an existing use so that someone can maintain their rights over time, or you're trying to work out, is one thing ancillary to a more dominant land use, and perhaps it doesn't need a permit, or perhaps it means something that is currently prohibited can continue to occur. Okay, so as I say, have a good read. Those two are kind of gold. You will use those a lot over time. So I'm just going to make some concluding comments and then we can finish off for the evening. So rather than just go through the lecture, I've sort of gone to these cases because I think while it means you have to look at this and I'll read it out to you, the skill, one of the key skills you can get out of this subject is actually starting to learn how to use case law. And as I say, it's super important sometimes to be able to do that, not just about ancillary uses or whatever, about lots of different things in the planning system. You'll find there's some sort of case law basis to the fine detail of how decisions get made. So I'll just go through these fairly quickly to make a couple more points. If things are for more than one purpose, you might find you don't need to get a permit for both of them, or maybe you do. So remembering that 6401 lets you consider ancillary land uses, and remembering there's a difference between the land use definition and the purpose. One of the principles, now I always forget how you meant to say this, indicia, this essentially means what is the circumstantial evidence, or what are the signs or indicators that are there, and in our case to think about ancillary or the purposes on land, what does it look like? If it looks like retail and there's heaps of people coming and it's the main thing going on, it probably means that that's the main thing. If it looks like a warehouse and all the indications suggest a warehouse, that's probably what it means. So it's kind of like circumstantial understandings are the basis of what evidence would be in this circumstance. Other matters that you might want to think about, and there's plenty of other cases that go into this in more detail. It's probably a bit beyond the scope of this subject, but sometimes matters of scale can be important. How much floor space is taken up by a particular activity or purpose? How much impact does it have? That could be noise or vehicle movements or vibration, all of those sorts of things. So they might have part of the considerations for whether or not it's ancillary. Whether or not there's an association between the principal or dominant use and the ancillary use. So in the case of the Video Easy circumstance, there was a clear link between that retail operation and the overall warehouse operation. But if they were warehousing for carpets, a retail operation for videos would not be linked, would it? So it would not be ancillary. So, as I say, there's plenty of case law about this. There's one, I can't think of the name of the case, but there are so many. If you look up ancillary land use, you'll get heaps. But there was a service station, and you've probably seen this yourself. You can hire trailers at service stations, but would that need a permit of its own? Usually not. But if it started to look like a hire centre and the petrol sales was a minor component, well, it would no longer have that dominant ancillary connection, and that would need a separate permit. So I think you're getting the idea. It's the use of these principles with a statutory basis and the application using the real and substantial purpose test, which we're going for. That's a summary of Casconi versus Whittlesey. Another good case, Alvaro Alfonso versus Casey. And these are just details of the things we've set out. I'll flip through these. Basically, these are things we've covered already. Existing use, 15 years. When does it expire? 2 years of cessation. And even things like, well, what exactly is the cessation of use? Stopping use. Details are set out in Nunawading versus Harrington. There's always more back there usually, or most times there's something back behind the decisions. Okay. And the final thing, well, often we're using these principles of ancillary, existing uses, and real and substantial purpose test. Well, does it even need a permit because something might be ancillary? What do we take into account? Because it doesn't have a trigger for a permit, and if it doesn't have a trigger, then it might cut out a whole bunch of decision criteria. And do people have notice rights? Do we have to take action because they're not complying with the planning scheme? And declaration is where we might ask the tribunal to establish for us, before we charge into a whole application, whether things are ancillary or not. So that's all. Thanks for your attention, guys. See you next week. And Andrew Walker comes next week, a well-known barrister.